Over the past week, there's been no shortage of reaction to the Supreme Court's recent decision in Montgomery v. Caribe, some of it measured, and some of it a little more breathless. So today, we're unpacking what the decision actually means for the transportation world, especially freight brokers, carriers, shippers, and insurers. The headline is simple. Negligent selection claims against brokers are not automatically preempted by federal law. But the practical takeaway is a bit more nuanced. This decision doesn't mean brokers are automatically liable, and it doesn't mean the sky is falling. What it does mean is that carrier selection, documentation, insurance coverage, and reasonable care standards are going to get a fresh look, along with new questions about broker liability coverage, emergent insurance expectations, and how brokers and carriers use data to manage risk. To help us sort through what changed, what didn't, and what the industry should do next, I'm joined by Prasad Sharma and Nathaniel Saylor from Scopolitas, Garvin, Light, Hansen, and Beery, and Dan Cook from TrueNorth Companies, along with, as always, my co-host Steve Kepler. So buckle up and come along for the ride. Hello and welcome back to our podcast. Today we are digging into the Supreme Court's recent Montgomery v. Caribe transport decision, a ruling that is already reshaping how freight brokers are thinking about carrier selection, liability, and safety. We're going to break down what the court actually said and what it didn't say, what it means for brokers, carriers, and insurers going forward. Super happy about this awesome panel. Today, I'm joined by a great group looking to unpack every angle. First, Prasad Sharma, attorney at Scopolitas Law Firm, Supreme Court watcher, hilarious fella. We've got Nathaniel Saylor, also an attorney at Scopolitas. He focuses on broker issues and is going to help us translate what that means, what this decision means for brokers. And then finally, last but not least, Dan Cook from TrueNorth, deeply experienced in transportation insurance, going to help us understand what this means for carriers, what it means for risk, coverage, motor carrier response, that sort of thing. Here along for the ride, of course, is my co-director and co-host of this podcast, Steve Kepler. Thanks, everybody, for being here. Excited about the conversation.
Thanks, Sean, and appreciate you guys joining us. This is going to be a great conversation, and we appreciate you taking some time. Maybe to start off, to set the context, Prasad, maybe if you don't mind talking a little bit about what the case decision involved and why the trucking industry should pay attention to it.
Yeah, thanks, Steve. So every case, the facts are important. And so I'll kind of just quickly lay out the facts here. You had a broker, C.H. Robinson, that hired a carrier, Caribe Transport. Now, you'll see C.H. Robinson isn't in the case name that's been circulated around, but they were a defendant in the case. What happened is one of Caribe Transport's drivers veered off course and ran into Montgomery, the plaintiff's tractor trailer, causing injuries. Montgomery, as the plaintiff, brought a negligent selection claim, negligent hiring claim against the broker, which was C.H. Robinson. And so that was the claim that was issued before the court. There were a couple of other claims that were brought. They weren't before the Supreme Court. They weren't addressed by the Supreme Court. They didn't make it on appeal. And really, the case was about, is that negligent hiring claim preempted by a federal deregulatory statute? So back in 1994, Congress enacted a provision called the F4A. Again, it was to prevent states from undoing deregulation, and it had a general preemption clause related to any state law that was related to prices, routes, and services of motor carriers and brokers. That preemption clause also had an exception. We call it the safety exception, and that's with respect to the safety regulatory authority of a state with respect to motor vehicles. And really, the court was trying to determine, what does it mean to, what does the phrase with respect to motor vehicles really mean? I'll quickly just get to the end. I'll skip the suspense. The court held that the negligent hiring claim was not preempted by the F4A. And it held that a negligent hiring claim because a broker is hiring a carrier to transport goods was with respect to motor vehicles and saved by the safety exception. No preemption. This decision settled a dispute split in the U.S. Courts of Appeals. You had two circuits. The Ninth Circuit was the first to ever hear this issue, and it held that the safety exception did apply, so there was no preemption. The Sixth Circuit followed in 2025, but in between you had two circuit courts, the 11th and the 7th Circuits, that held there was preemption. The safety exception did not apply. So that's why this case came before the Supreme Court, and that's how they held.
So thanks for that. And I think, we've heard there's lots of this out in the media, right? Some are saying the sky is falling, others maybe not so much. You think that the court's interpretation of the safety exception, does that really change the legal landscape much, or maybe what are your thoughts there?
Yeah, so I wouldn't say the sky is falling, but it does change the legal landscape, but at least in federal courts in the 7th and 11th Circuits, where they had held preemption did apply. But even there, keep in mind, so the 7th Circuit is parts of the Midwest, the 11th Circuit is states in the Southeast. Even there, if the claim was in state court, they weren't bound by the appellate court decisions, the federal appellate court decisions. So there was some variation even there. I think from a practical perspective, if you were a broker that's operating nationwide, you still had to take into account the risk of negligent hiring claims being brought against you. You couldn't just rely on the 7th and 11th Circuit decisions. What the Supreme Court decision does, it brings clarity. And it's, obviously it would have been more helpful for the brokers if the Supreme Court had found the claim preempted. But there is certainty now going forward.
Is that, Prasad and Nathaniel, too, one of the bigger misconceptions of the ruling, that like the legal landscape or the bar that brokers need to live up to has changed? Because it sounds like you said, well, if we're in state court, they should really be doing this anyway. But at the same time, I know Steve and I'm sure you all have been hearing from brokers and carriers trying to react to this. So, what is the misconception, and how are we expecting them to react?
Yeah, I for my 2 cents, and Prasad, feel free to jump in. I think, it's a couple things, right? It's before the case came down, I think you'd be forgiven from reading media reports. I think you would think, oh, if we win this case, brokers are never going to have liability again. And if we lose this case, we're always going to be liable. And neither of those things is true, right? But even had we won the case, there are still other causes of action that get brought against brokers, and they were not before the court. Only the negligent selection claim was. So there was still potential exposure for brokers there. After having won, after having lost the case, the narrow question before the court was whether the claims were preempted, which is to say it's a procedural defense. It's either you have a claim, plaintiff, or you do not have a claim. The court really didn't put its thumb on the scale, nor should it have, that it wasn't before the court, as far as what constitutes reasonable care by a broker. So a negligence claim is essentially an allegation that somebody failed to exercise reasonable care. So the question in a negligent selection case is, did the broker exercise reasonable care when it engaged this motor carrier? That's not a question that was before the court. This case is going to have to go back down to the trial court for a jury or a judge to make that decision as far as whether reasonable care was exercised. And so that, in that regard, kind of nothing changes as far as, if you were in a jurisdiction where you didn't have preemption before, you had an obligation to exercise reasonable care right up to the date of this decision. It's a long-winded way of saying, you could convince yourself that, hey, if I was comfortable with my carrier vetting protocol 10 days ago, I should be comfortable with it today. I think, what people are struggling with is now paying attention to their carrier selection protocol, maybe in a way that they weren't doing before the decision, and really asking the hard questions of themselves as far as, are we do we feel like we can argue that we're exercising reasonable care?
Were the stakes then so high because if the court had decided the other way, then brokers would have been in a much stronger position to always argue that safety exception? Is that why we were all so there was just eager anticipation for this result?
Right. I think it's,
why were we eager?
Yeah, I think it's I think it's that, had we won, negligent selection would have been off the table everywhere. And I did mention that there are vicarious liability claims that could have still been brought even had we won. But, and I think this is really the piece of it, why brokers in particular were so hopeful of a favorable ruling. These negligent selection claims are just extremely difficult. I think we'll get into more of this later in the discussion, but there isn't a standard as far as what constitutes reasonable care. The question is, what every state has its own definition of reasonable care, and we don't have decisions in every state addressing brokers selecting motor carriers, right? And so we don't have decisions we can point to say you did enough. And what that creates is a vacuum, right? There's a vacuum of case law. And so as a broker, you can't point to anything and say, oh, as long as I do this, I've exercised reasonable care. And what that does is allow the plaintiff's attorney, in this vacuum, now the plaintiff attorney has the easy task of just pointing to all the things that maybe you could have done, right? And they start to plant seeds of doubt in the jury's mind as far as, well, why didn't you do this? Or why didn't you do that? And it makes these claims very difficult to defend, very difficult. Dan, I would be interested in your thoughts, but I think it makes the claims very difficult to price out, basically, to value. How do we think about valuing a claim or settling a claim when we really have no certainty as to what the jury is going to think is whether we exercise reasonable care?
What do you think about that, Dan? What do you think about?
Yeah, I like to provide just a little overarching comment here. I really appreciate the pragmatic, non-emotional, kind of level-headed tone that's being taken to this discussion. I have been incredibly disheartened with the approach taken by many who have a microphone from within our industry. Defense counsels, industry prognosticators, supposed experts that have ginned this issue up. I think we're creating a bit of our own problem, and a problem for both motor carriers and freight brokers that probably doesn't exist at the degree, certainly, that many are pontificating. And so I do think that there are some defense challenges to these claims. I do think this ruling has made the situation for freight brokers, particularly those that don't run sound risk management practices, more difficult. I know it has certainly gotten the attention of the underwriting community, but it is all degrees more than it would have been had everyone taken this measured approach to their commentary. I would agree from an underwriting perspective, not a lot has changed. The change that's occurring is that which we are creating as an industry for ourselves, and others are gonna prey upon
that. To give you just a little context, I think the first case that really brought these types of negligent selection, negligent hiring claims against brokers to light was a 2004 case, Schramm versus Foster. So this is dating back to 2004. And the first case that held there was actually preemption at the appellate court level didn't occur until 2023. So this is an issue Yeah, this is an issue that brokers have been dealing with. Now, mind you, there were district court cases that held preemption before 2023, but 2023 was the first appellate court case to do so.
Well, I think just picking up on that, and Nathaniel, kind of your track of conversation, so how do you think reasonable care and carrier selection is going to be defined for brokers going forward? Is it, wild, wild west?
You're probably not receiving any questions about that.
No, none whatsoever. Well, and
I'm about to take
notes. Right. Yeah, if I had the answer, I wouldn't be here on a Friday before a holiday. I'd be on a beach somewhere. But before I jump into that, Dan, that point is, I think it's a really well stated point, and I think Prasad pulls the exact right data point to illustrate it. Right. I mean, it's like we've been dealing with these claims for 20 plus years, and that the first preemption, we weren't winning preemption on these claims until even at the lower court levels, to Prasad's point, 6 or 7 years ago. Right. I mean, it's just that this has been an issue that the industry has faced right up until the decision was issued, and just will continue to face. So it's an excellent point that Dan made. As far as how to think about carrier selection, like I said, there's a dearth of case law. There's a vacuum, as far as what we can point to say, well, yes, in this instance, this is clearly reasonable care, because all the plaintiff has to do is to create questions. And so you can do, to demonstrate the point, I'll just do a very brief thought experiment, but take one hand, a broker that just says, you know what, we're not going to consider the FMCSA's basic scores in making our carrier vetting decisions. They were ordered to be removed from the public view by Congress. They're not indicative of crash risk. They're not reliable. Well, in that instance, if that carrier or that broker engages a carrier who's involved in an accident and is sued, they're going to be defending the question of, well, why did you think it's okay to ignore this important safety information from the FMCSA and these important scores? And of course, the broker's defense there will be, well, because they're not indicative of crash risk, they're not reliable, and the FMCSA was ordered to remove them from the public view. And so that's the hill that the broker is going to have to die on. Now take another broker that may be set
or survive.
Yeah, exactly. That's yes. Thank you. That's an important point, right? Is like, we do have a pretty good track record of defending these cases on the merits, and it's important to bear in mind. So thank you for that. And then the flip side of that coin would be, so now let's say it's a broker that did consider the basics. Well, if you're considering basics, you're going to have to, as a practical matter, use carriers that are over 1, maybe 2, maybe even 3 basics. You're going to have to set your parameter where at least some of the carriers are going to be over. Well, in that instance now, and let's say that the carrier here was over 2 but not 3 basics. Now the plaintiff comes in and they don't argue that you ignored this important safety information, but rather they argue what you did with it, right? Well, this carrier was over 2 basics and you still decided that you could use them, right? And so all that to say, as you're thinking about your carrier protocol and what constitutes reasonable care, I think a few high level comments are important, right? And one is just some professionalism around the issue, right? So you would be shocked at the number of brokers I talk to and I ask them, well, what's your carrier vetting protocol? They say, well, they tell me the system that they use. Oh, well, we use XYZ carrier vetting service. Well, that's not telling me what you're vetting to, right? I mean, when you onboarded with that provider, you probably told them, what you wanted to vet to. Right. And so, if you don't even know what your standard is, let's say 2 brokers have the exact same standards, right? One has their policy written down. It's very clear who's responsible for that policy. It's very clear, there are no exceptions from the policy, et cetera. And then the other broker, doesn't know what their system is, but they're both vetting to the same thing. Who do you think is going to sound better in front of a jury and in a deposition, talking about whether they exercise reasonable care, right? It's the one that had the informed policy, that knew what they were doing, that had the right chain of command. Even if it's two brokers, they had the exact same vetting criteria, right? So those are the, as you think about it from the top down, before you even get to the detail of what you're vetting to, is, just that professionalism, right? And this is a core competency for us. This is something that we take very seriously. It's one thing to put that out in a press release. It's another thing to live it every day.
So can I ask a dumb question? And this is probably really, really dumb, but I'm going to ask it.
There's no dumb question.
Depends
Not
on
that's
who
from
you ask.
Prasad, right?
Okay, so Steve Kepler Brokerage is being deposed because of some crash. Does plaintiff's attorney ever say, well, Prasad Sharma Brokerage, they have decided this is their level. This is how they want to vet. These are the services they use. These are the number of basics, whatever it is. Or is it always sort of fact specific? Is it always like in this spot? Like, so say it another way, C.H. Robinson decides to create their own standard, or there's this industry group out there that is like, we're going to create the gold standard for everybody. And then will plaintiff's attorneys be like, well, why did you decide you're not going to do what the creme de la creme does?
Right. Yeah, I mean, certainly that's a risk, right? You're always going to have experts. These cases often involve expert testimony, from the plaintiff side and the defendant side, and you can imagine, how likely those two experts are to line up. Interestingly, to exactly your point, literally within days of Montgomery, I've seen email strings where attorneys are reaching out, talking to one another. Defense counsel are talking to one another, saying, my broker clients are getting subpoenas in cases that they are not involved in, asking for their carrier selection criteria, right? And I think it's because the plaintiffs are wanting to do exactly what you just said, Sean, right? They're trying to figure out, what's the standard, and what are people doing. And certainly, if you get one of those subpoenas, talk to your defense counsel. There might be ways to quash that subpoena, and hopefully protect that, because that is your secret sauce, right? That is proprietary, confidential business information. But I think you're exactly right. You're going to start seeing, even if they don't try it out in your specific deposition or litigation, trying to create what the standard is and try to use that against you.
Yeah, I could speak to another way in which we've seen them go about it, and it's likely to become more pronounced. For those underwriters, and there's a limited number of them that offer true broker liability coverage. I'm not talking about just simply contingent coverage, but broker liability coverage. There are carrier qualification standards that are pretty generally accepted. And so by virtue of the underwriting process, we have refined over the last several years kind of some basic standards. It's kind of like it equates to today, if you want to get cyber liability insurance, you have to have dual authentication. Now, there's nowhere in a federal regulation that requires anyone to do such a thing. But to get that coverage, the insurance industry said that's kind of the price of poker. If you look at the leading writers of true broker liability, there are some common themes, and we have seen plaintiff counsel looking for that information, finding that information over the last few years, going as far as asking a broker, provide us a copy of your last insurance renewal application for your broker liability. Didn't you agree with your underwriter that these would be the carrier qualification standards that you followed? Did you follow them? And those are commonly things like no use of conditionally rated motor carriers, no use of carriers with more than 2 CSA scores. You will not fine carriers for delay or exert overt control. You'll ensure that your carriers, you have auto liability insurance with an insurance company that is rated A- or better with AM Best. You'll ensure that the bill of lading do not have your name on it as a broker. And there will be restrictions in the broker carrier agreement against co-brokering. Those 6 items,
we finally figured out who's writing the rules.
Yeah, you will see those 6 items appear over and over again, and they have for years, because the insurance underwriters never approached this business as if there was preemption.
Yeah.
So,
well, at least the legitimate ones, right?
Yeah.
Sean, since you invoked Prasad Sharma brokerage, maybe I'll wait.
I've got the higher standard.
Dan Cook carriers.
Yeah, no, so it is obvious that people would be looking at Prasad Sharma brokerage as setting the standard for the industry.
Obvious.
And again, I think you have to understand the test is what is reasonable. And I think what plaintiffs' attorneys are always trying to do is they're trying to point to, hey, there is an industry standard. The industry standard is X, and what you, defendant, did fell below that industry standard, so that was unreasonable. So that's the kind of plaintiff's playbook. And I think some of the things that Dan just recited get to that, what is reasonable for negligent selection, negligent hiring. Some of the other things that Dan cited too about, not being named as the carrier on a bill of lading address other potential causes of action, not directly related to negligent hiring, the issue that was before the court.
Well, that's great.
Okay. Sorry, Steve. This is a quick, dumb question. We're talking all about brokers right now. Are we also talking about shippers or not?
My 2 cents would be yes. Prasad, again, interested in your thoughts here, or some additional nuance. Maybe there's nothing about so when you talk about a tort claim or tort liability or a negligence claim, there are elements to the claim. In other words, you have to prove duty, causation, breach of duty, damages in order to prove a negligence claim. Nowhere in that list is that the defendant was a broker or a freight forwarder or a logistics company that gets paid to arrange transportation. So there's nothing that expressly limits the liability to brokers or forwarders. Shippers have been sued for negligent selection claims periodically. There are some cases that suggest that brokers or forwarders may have what we call a heightened duty of care when with respect to selection of carriers, but usually in dicta, not binding decisions. And so dicta just meaning a part of the ruling that is just something that the court said that's not binding on anybody.
Yeah, I totally knew that.
I knew you did. I was for everybody else. But and so, shippers could be sued. I think some of the, and you're seeing a lot of this in the way this case is being reported, right? Shippers tend to use larger carriers, and they tend to go to brokers because brokers can amalgamate, capacity using those very small carriers that frankly it's the shippers can't go to because it's too burdensome for them to onboard so many smaller carriers, right? So they treat the broker like a source of capacity, just like they would a large carrier. But so for that reason, maybe the shippers are less likely to get pulled in, but there's no reason that they couldn't be. At least that'd be my 2 cents. Prasad, happy to hear your thoughts.
I'm not going to add any nuance necessarily, but I think it was interesting. There had been some cases that had found preemption applied to claims against shippers as well. Even though shippers are not named, that you can't find shipper anywhere in the F4A statute, the preemption statute. There were courts that held such claims preempted even against shippers. Obviously, that's a dead letter now under this decision.
So maybe we can track a little bit to talking about motor carriers. Maybe Dan, toss it to you. What's your thoughts on how this decision could impact on carriers, right? Particularly those with maybe weaker safety profiles or a lack of data? Do you think this could impact on their ability to get freight? What are your thoughts there?
I do. I think this is creating a hypersensitive environment. We, we like scope leaders have a front row seat with shippers, brokers, and large motor carriers. And there is an elevated degree of caution about carrier selection. And I think that's going to be around a while, regardless of the actual legal impact of this ruling. Everyone is taking a fresh look at their risk management position and the controls that they have in place. And it's, why take the risk if there is capacity available that is safer to utilize? And so there's an opportunity for the large brokers that have very good controls and vetting processes in place and can demonstrably show that to a shipper to use that to their commercial advantage the same way that a more established motor carrier can. And I think you're going to see the insurance industry fall in line with that as well. I think we're going to see more restrictive underwriting. Those 6 requirements that I mentioned might become 8. There's probably going to be more verification or authentication that those things are actually occurring rather than relying simply on the statement of the applicant. So it's going to get tougher for, I think, all smaller forms of capacity. I think that's a fair way to say it, whether it's brokerage or carrier. And I'd be interested in other people's take on that.
Yeah, me too. Nathan, any thoughts? One of the things that's popping around in my head about this is I have been thinking about who gets the advantage here. And I know that we started the podcast by saying really the playing field is as level as it was or the same as it was before. So maybe we're talking more broadly now, but who gets the advantage on this? A small carrier with no data, which is highly likely, or a brokerage who's been around, or a carrier that's been around for a while, maybe isn't all that large, but is starting to accumulate some data. I mean, yeah, what do brokers do with carriers with no data at all? And vetting to a standard, this carrier's got 3 clean inspections, 4 drivers, 1 million miles a year.
Right.
What do I do?
No, that's a really good question. I think, the broker, so I would say this, a lot of brokers have started to adopt rules that look at the length of time in service for the motor carrier before they even start looking at safety information. I think it's for exactly that reason, right? Because the carrier is, hard to define as far as safety goes unless and until they have some operational history. And some of that, frankly, is as much brokers are concerned as much about fraud as anything, right? They want to see actual inspections because, if you had your authority and you don't have any inspections, it would indicate that you're maybe double brokering freight, et cetera. So while a lot of that vetting for time in service might be tied to fraud concerns, it still dovetails to the safety concerns and allowing the carrier time to develop a little bit of a safety record that you can then vet to. Having said that, for a broker that maybe doesn't have that sort of a rule, length of time in service, I think what I'm guessing is your intuition is correct in that the broker is probably going to use that carrier with no issues, right? Because you're usually looking for problems. And in the absence of problems, right, there's no reason to not use that carrier, especially when you think of, and maybe that's a bit of a broad brushstroke statement. I think that's the right answer, though, for brokers that are automated, right, that are, essentially, having their carrier vetting service pull out carriers that, trip certain boxes. And so I think for, the new small carriers might get hung up, and it might be very hard to start a new carrier right now trying to rely on brokered freight if you don't have that operating history. I could see, I could see those carriers struggling mightily. Certainly, conditional carriers, I think, are going to have a really tough go. And then from there, the carrier that's been in business for a little bit, if it's got a clean record, that's a very appealing carrier to a broker. It's once they start to have some issues, that's where you're going to start to see some brokers will work with them, some won't, depending on where they set their criteria.
Nathan, you make a great point. I just want to caution us a little bit. The comment of carriers that have no data. If you follow the LinkedIn feed, there's been a ton of conversation recently about the 90-some percentile of carriers that have no data. And that's not an accurate statement. The statement is that they don't have CSA basic scores established yet. But there is data available on every carrier. It might just be how long have they been in business. It might just be some inspection information. It might just be VIN numbers or driver identification. And are they showing up in chameleon carriers? But there are better underwriting tools. There are better carrier qualification tools emerging or being expanded. There are means today to evaluate carrier capacity outside of CSA basics that brokers are considering and deploying.
Well, that's great to hear, Dan. I figured that was the case. I think it's an important point that you make there. And Nathaniel, I think one of the things that, and this was an issue even before this ruling, there was been media reports of companies selling DOT numbers so they can have more length in service, fraudulent activities.
Or even stealing clean inspections from legitimate motor carriers.
Yeah. And I think that's something that folks need to pay attention to, because I suspect that may try to accelerate given this situation, which is something for everyone to be watchful of for sure. So I think,
Stephen, can I just jump in real quick? We were talking about some challenges for smaller carriers, and let me offer maybe these are my perspective, maybe a different way of thinking about it too, and maybe think about why these claims are being made against brokers in the first place. I think over the last 15 years, you've seen verdicts for accidents, verdicts and settlements have been skyrocketing, right? We all know in the industry, we're all fighting for reasonable tort reform measures to address these runaway excessive verdicts. And I think what you've seen is plaintiffs have found, okay, the carrier that caused the accident has $1 million auto liability policy. I'm looking for more and deeper pockets. I'm going to turn to the broker or the shipper that hired the carrier. And that, I think, poses a problem too for smaller carriers that aren't able to build up the kind of insurance moat that might instill a little more confidence. Now, that said, these verdicts are getting to the point where I'm not sure anybody really has the capacity to provide sufficient insurance. So that's a longer term issue, and that's why people like Dan are out there pushing for tort reform across the country.
Well, that's a great perspective. I thank you for offering that, Prasad. So maybe shift tacting a little bit. Let's talk a little bit about how we demonstrate reasonable care. And maybe Nathan, start with you. Any thoughts from a documentation standpoint? I mean, trying to wrap our arms around, okay, what do we need to do really to make sure we've got all our ducks in a row? What are your thoughts there?
Yeah, and I think, I want to circle back to a point that Dan made. it's a hugely important point to think about your insurance policies, right? So in other words, not only what did I agree to as part of the underwriting, but then because to his point, that will be trotted out potentially in litigation and said, well, in your application, you said you would do these things. Did you do these things? But then also, we're starting to see those as conditions precedent now in policies themselves, meaning you don't have coverage if you're not doing X, Y, and Z, which is, so I would say as you think about drafting your policy, one thing you need to be thinking about is, well, is my policy going to be voided? Is my coverage, going to be voided if I don't, and you've got to build in and comply with anything that you agreed to as a condition in your insurance policy, not because that's going to create legal liability, although it might, but rather because without it, you won't have insurance, or you won't get defense or indemnity against the claim. So from there, I think, and it's a bit like we touched on earlier, right? We'd love to see an informed, vetting policy that is a living, breathing document within the company, maybe identifies, the individual or the team that's responsible for that document. And, ideally, it can be a couple of different, you can have the policy itself, right? And then separately, you could have training materials that instruct your personnel how to actually implement the policy, whether that is training to a small team of people that are vetting carriers, or whether that's training to the end carrier rep who is responsible for actually sending the load to the carrier and just showing them here in the system, if it shows yellow, and if it's because we need a certificate of insurance, well, that's fine. We just need to go get the certificate of insurance. That's different than, being a conditional rated carrier, et cetera, right? So, having your protocol that sets what your standards are, and then having some training materials, I think all of that just helps again show, professionalism. We've put some thought to this. And then, maybe periodic check-ins with the policy, right? Maybe twice a year, that team that's responsible for our vetting program meets, sits down, talks about it, or maybe post-accident. You need to be a little bit careful about what you do post-accident and how you communicate it. But, it's a good time to sit back and take stock. Did this accident occurred? That doesn't mean we did anything wrong. It doesn't mean there's a problem with our protocol. But is it an opportunity for us to try to learn something, right? So I think, those are the types of documentation we would love to see. You in an ideal world, there would be very little discretion built into the policy, or really none for that end user. If we're going to have discretion, ideally it would be discretion that is exercised by a smaller team, maybe some management within the company. And what I mean by discretion, I don't want to see a statement in a policy that says, to the end user, look for a carrier with a clean safety record or with good scores. That doesn't mean anything. That doesn't tell me anything, right? What we want to see is, no, if these are where we set, if we're looking at basics as an example, this is where we set, that's automated. There's no discretion there. That end user doesn't get to change anything. But then if we do have an area, an issue where maybe we have some discretion built in, maybe having to do with, I don't know, if you're going to use conditional carriers, which again is a higher risk proposition, but if you're going to use a conditional carrier, maybe you have some rules built in to say, we'll only use a conditional carrier if they provide us a corrective action plan. There's going to be a team that looks at that corrective action plan, makes sure that it gets to the core issue that resulted in the conditional rating. We're going to make sure that the scores start trending in the right direction. And if they don't result in a satisfactory rating within 90 days, we're going to stop using them, right? That's an example of where maybe we have some discretion built into the policy, but it's not exercised by that, the end user, especially if that end user is compensated based on the number of loads that they, or we don't want that financial tie with the person that's making that end decision, if you will. Last thing I'll say real quickly, I apologize to be so long-winded on this question, but you there's safety vetting and there's fraud vetting, right? And sometimes the two, crash together, and it's hard to tell kind of which is which, right? But I would say, for things like fraud vetting that are obviously fraud related, discretion is that's far less concerning in that context. So what I mean is, if your system is flagging, well, hey, the carrier had a change in address or a change in contact information, you might be very concerned about that, but you might not be, right? And that's one where if you override that in your system, that shouldn't have a heavy impact in your highway accident liability risk. Whereas, if you're overriding your safety rules, I mean, that's absolutely going to be a problem in litigation.
Where does it start and stop? Like, I really appreciated Dan's comment about, hey, no carrier's got zero data. I think that's like a really good statement. And I just wonder, like, how long we have to keep pulling on this thread. And there's probably no answer to that, right? Because it's always about a balance of facts and, fact-specific scenarios. We've got the brokers in Congress are trying to pass they have been for years and years, I think it's called the Motor Carrier Safety Selection Act, which kind of indemnifies them as long as they check this box, that box, and the other box. But like, however this question is supposed to be asked, like, where is it safe to stop? Right? Like, do I have to research the full history of all VINs being used? Do I have to verify that the VIN I understand to be hauling my freight is in fact the VIN, that is hauling my freight? I mean, you could go forever. So I guess, how do I build my,
right?
What do I do?
Well, I'll let Prasad tackle the make a plug for some tort reform at the federal level, Prasad, because I think that's really the answer is a national carrier vetting standard, and certainly TIA and other groups have been pushing hard and continue to push hard for that, and for exactly this reason, right? Because where do you stop? I think at the end of the day, and again, in the vacuum where we don't have hard and fast rules, it's easy to get yourself caught up in, exactly that, the plaintiff position of, they always get to just move the goalpost on you and argue that you should have done more. But Prasad made the point earlier.
Yes.
Yeah, right. And it's, they're always just, whatever you did is not enough, right? That's where they start. And then they say all the things that you didn't do. And I think, what's important to bear in mind is your obligation is one of reasonable care. And, as a defense bar, we do have a pretty good success rate of actually defending these claims on the merits and proving, that you did exercise reasonable care. And I think part of the way that we do that is through, expert testimony that, you need to help the jury understand how the industry works, right? Because they're only going to get presented, if you let them, they're going to get presented one carrier selection decision in one circumstance, and that carrier selection decision resulted in an accident, or we wouldn't be here having this discussion, right? And you need to help them understand that, me, you, and they want the thing that they ordered in 2 days. And for that to happen, the broker isn't, it's not like we're contracting with 10 carriers and we, go on site and we look at their operations, right? On site, their operations is the guy's house, right? I mean, it's, that most people don't understand that. They don't understand how freight moves in this country. And it's our job as, defending these claims to help people understand, what that looks like and what that means. And some of that is we can measure against, the FMCSA does have, as an example, a definition of a high-risk carrier. And if you're a high-risk carrier, you're not prohibited from operating. It just means you get put in line for an inspection. And if our vetting criteria is something south of a high-risk carrier, right, that gives us something that we can point to give the jury context to say, oh, okay, like you can be this, be considered high risk by the federal government, but still be allowed to operate. And the broker was doing something, more conservative than that. And that's how we try to frame that discussion of, of reasonableness. Because to your point, yeah, we could, you could go forever. And the more you do, the more vetting you do, you start to open the door to those vicarious liability claims we talked about earlier. It's a catch-22, right? The more I inspect, the more I, if I was going to go and look at the carrier's operations, or if I was going to do driver-specific vetting, well, now I'm opening myself up to those vicarious liability claims based on control. And so it's a slippery slope for sure.
So I think one last point, just picking up on that train of conversation, I think then we'll shift to talking about some insurance related stuff. And it's related to kind of FMCSA data and real-time data. Brokers, vet their carriers, whatever, however their frequency is. Maybe they do it once a year, maybe they do it twice a year. But we know the basics are rerunning their scores every month. Right. And so do you have how far should that, if they're looking at that data, how frequent should they be looking at that? You guys have some thoughts there to what is kind of standard practice, and what
every time they book a load, or when they sign up the carrier?
Right. Well, I think, a lot of brokers that are larger brokers that are using vetting services, it's automated, right? They're getting their service is integrated with FMCSA. They get, the service gets the data dump every night, cross-references the broker's criteria, cross-references the broker's carrier stable, and pulls out the carriers on a daily basis. And so, that's great for those brokers that can do that. And then the question is, okay, well, what about the brokers that aren't integrated? And again, it gets down to the amorphous question of, is it reasonable care? Prasad, correct me if I'm wrong. I think under the national hiring standards, there's usually been maybe like a 30 or 35 day window where that were proposed in Congress that didn't pass, but it's
right. Correct. I think it was a 60-day window.
Yeah. So, I mean, and again, not that that's a rule that's binding on a jury as far as, oh, well, you didn't vet them for 60 days. But, that even if we see a national hiring standard, that's one of the things you're going to see there is clarity on, how frequently, if you vet this frequently, you qualify for the safe harbor. And if you don't, then you wouldn't qualify for the safe harbor. So I think that's just going to boil down to the question of how the fight in absent the national hiring standard with the plaintiff is going to be how onerous was that vetting and how often did you do it, right? And if it's something that you could have done very quickly and very easily and you didn't do it, they're going to try to hang you with that. And obviously we're just going to have to argue the opposite and say, well, look, this is a manual, invasive, labor-intensive process, and this is how often we decided to do it.
Awesome.
And just to be clear on the national hiring standard legislation, the vetting that is required is less intensive than looking at the basics. It's looking to see, does the carrier have operating authority? Does the carrier have insurance, which it should have if it continues to have operating authority? And does the carrier not have an unsatisfactory safety rating?
Unsatisfactory, which would put you out of business anyway. So really we're saying, are you in business? That's the standard.
Are you authorized to operate by FMCSA?
Got it. Interesting. Yeah, Steve indicated, let's turn to insurance, Dan, and just curious to know what the insurance industry is thinking about this. And you had mentioned, there's not a lot of lines of insurance for brokerage, but also could it impact carrier insurance as well for carriers who might not, meet whatever standard we've decided is reasonable, but perhaps you're already pricing that in. So insurance is not too worried about what's happening in your world.
It's all over the place. And I think that's the function of the way that this has been addressed in the various forms of communication that are out there right now. The reality is we were pricing it in. The insurance industry, by and large, I've not spoken to an underwriter leading up to this verdict that thought the ruling was going to go any other way than it did. I think the insurance industry believed that preemption did not apply. And that is the way that programs were priced to this point. Now, there are going to be some underwriters that are opportunistic here. There's going to be underwriters that legitimately feel like it's created a new level of uncertainty, and they're not sure they've priced for that level of uncertainty as they're assuming this risk. So there's going to be a period here where it's challenging. I want to tranche it, though, into different buckets. I think that's really important here. The underwriting community, the number of underwriters providing true broker liability coverage is a more limited pool than the very large number of underwriters that provide contingent liability. And I want to say, unfortunately, and I'm going to refrain from that.
Can you just define for me contingent liability, because I'm just a dumb
But
guy.
At its root core is contingent liability only responds when there is no collectible insurance with the carrier. Absent that, effectively, there's no insurance coverage for the broker. And I'll step back from that a little further and address a misconception, a misunderstanding in the industry that I've heard many times here recently. I think there's a false belief out there that somehow the $75,000 bond that brokers have to post is some form of insurance, and it is not. The purpose of
What do you mean? 75,000 is not going to cover a crash? What are you saying?
It doesn't apply to a crash, is what I'm saying. The bond is simply financial security that protects the carriers and shippers in limited instances of fraud by the broker, and if they fail to pay the carrier. That's what that pool of money is there for. It is a bond. It is not insurance. And there's nothing out there that requires, other than perhaps if a shipper were to require so, there's no legislative requirement the way there is for carriers that brokers carry any insurance at all, much less the form of insurance they carry. So you have brokers that are able to qualify for what I'll say is the superior form of coverage called broker liability. A limited number of shippers are fully aware of the distinction and require broker liability. However, most shippers pre-Montgomery just required the broker to have a limit of liability protection without specifying whether it was contingent or broker. And we might see a shift there. I think we're going to see more awareness. One, I think we're going to see more brokers want to be able to get the broader coverage because they know they need it. And that means they're going to have to instill some of these vetting and control procedures that maybe they had been avoiding the cost of in the past. And I think that's going to be partially driven also by the shippers now wanting to ensure that not only does the broker have insurance, but they have a form of insurance that's going to be more responsive when it's required.
Well, I think that's very insightful, Dan, and I think one of the byproducts of that, if it does happen, is hopefully it will squeeze some of those brokers that maybe shouldn't be doing in the business out of the business because they're rolling the dice, right? And hopefully it will clean things up a little bit. Will be one of the byproducts of that. So do you think there'll be any new products emerging on the insurance side for this, or is it any thoughts there yet?
I think there is new capacity currently being formed for freight broker liability. It's going to be interesting. There's a significant new underwriting facility that's about to open for business. And it'll be interesting to see if this creates any pause there with that capital. I don't think there's a big need for new products. I think the products exist for the risk that's out there. And so what the question will be, will there be a retrenching? And I'll tell you one place that I could see where capacity goes away. There are still a lot of motor carriers that have a brokerage operation that is, especially smaller motor carriers, that is insured by their primary auto liability insurer. Almost as a favor, while that underwriter's core focus is writing auto liability, they also are providing contingent liability, perhaps brokerage, generally contingent liability for that motor carrier and their relatively small brokerage operation. I think you're going to see a number of these underwriters go, wow, we've got more risk here. It's created an awareness. We've got more risk. We can't just give that away. We can't dabble in that. And if I were a broker, I want a really strong claims team at my broker liability carrier. I want to be insured by somebody that can defend me at a high level. And if your truck insurer is doing you a favor and dabbling in contingent or brokerage liability, they're probably not well equipped or as well equipped to defend the claims that occur.
The only thing I'm going to say is that's an excellent point, Dan.
Yeah, for sure. Absolutely.
Yeah, thanks for sharing that. That's good insight.
Well, we're kind of sliding into home here. We've been going for a while, and I think we've got a lot of good points. I think I know the answer to this. Everybody's wanting. You mentioned at the top, Dan, that everybody's wanting to say what the big impact is. Like, how does this reshape the industry? And I think we've talked about that maybe the impact's not as big, and that lots of people will continue to take risks. Now, we put it in context with your comments about insurance and new insurance products and being more aware of that. Do you think, I've just been wondering if we'll start to clean the industry up a little bit from a perspective of, less safe carriers, making it harder for them to get the freight, right? I mean, yeah, there's a lot of good in the industry, and there's also a lot of carriers that maybe aren't making the best choices all the time. Are there any larger impacts here? Are we going to see anything, and that's for everybody. Are we going to see any of those impacts, or do you think we're just kind of business as usual? Not to say that's necessarily a bad thing, but there's a reason freight rates get dragged down sometimes by carriers who aren't the best.
I'll take a
Steve, you got to answer first.
Yeah, there you go.
Go ahead, Nate. Go ahead.
No, I was just I'll just because I can't stand an awkward silence. I think I tend to, right. I mean, I think, in other words, you could see some capacity. Well, you could either see capacity leaving the market from those smaller, unsafe carriers, or the conditional carriers, right? The ones that do start to find it more difficult to get freight. Now, what does that look like, though? Does that actually result in capacity leaving the market, or does it result in, chameleon carriers and attempts at shifting things around? Or does it result in some of those smaller carriers, that are one or two truck operators becoming owner operators for very large motor carriers? All of that, it's either going to pull capacity out of the market, or it's going to shift where the capacity's at, right? And I think my guess is that, well, what do I know, right? I would just, being a rational person, I would think it would be more of the latter, right? If I've got a truck, I might as well use it. Yeah, I think that'll be the, if anything, I don't know that it will result in a lot of capacity leaving the market, but it might shift where the capacity's at.
I just throw in too. I mean, it's one thing to identify unsafe carriers. I think there is a reflexive painting with a broad brush that small carriers are unsafe. And I think we need to be very clear that is not the case. I do think, again, part of the larger trend of this whole industry being under the pressures of increasingly excessive verdicts. I think that is creating a little bit to what Dan mentioned. There's going to be interest in who has the proper insurance coverages and in what amounts, as everybody tries to create a little bit of a moat to deal with what is, the risk of doing business. And ultimately, I think the big question for the public in general is, do you want these goods delivered and at what cost? Because all of this has a cost to the providers in the supply chain.
That's a really
Yeah,
good
guess,
go ahead, Dan.
and I would close on this in saying I think there's going to be a lot of good that comes out of this. I think that we are going to run better brokerages and better small motor carriers as a result of this, whether that is an elevated interest in risk management and your capacity management in this area, or whether it is the purging of some of the unscrupulous both small carriers and brokers. And I think it may even be more impactful on the brokers that are operating in an unscrupulous fashion. And often those two are closely aligned. That is the capacity that works with that brokerage population. And I agree 100% with Nathan. I think you're going to see good small motor carriers aligning with larger fleets or capacity. But the ones that are unscrupulous in many instances won't qualify as a driver for those fleets. And that will be exactly the ones that have to exit the market and the ones that we want out of it.
I really like that. I want to kind of slide into home here, but first I want to ask Prasad. We talked about the Motor Carrier Safety Selection Act. It's been introduced and reintroduced since, you could probably tell us better. I would guess I'd put the over under at like 2012, 20 somewhere
roughly. I don't have the exact, but yep, it's been a while.
Yeah. Do you think we'll get any more traction on that following this decision?
So at its high water mark, there was a Congress in which it had passed, I think it was perhaps during the last highway bill, but where it had passed as part of the House version of the highway bill, and it did not make it through in the Senate and dropped out during conference. This court case obviously has generated a lot of attention, a lot of commentary. I think for the public more generally, the Supreme Court's oral argument and the opinion has highlighted that FMCSA doesn't have safety ratings for 95% of carriers, that there are challenges. I think Justice Kavanaugh's concurring opinion, which was joined by Justice Alito, pointed to some of the challenges that brokers don't own or lease equipment, brokers don't hire drivers, brokers don't always have access to information to make these decisions. So I think a lot of this maybe builds towards more pressure for Congress doing something. But again, this is safety has always been one of the state's police powers. Congress is usually wary of preempting the state's police powers. So there's still a lot of work ahead before something like the Hiring Standards Act gets enacted.
And that's not in this version of the highway bill that dropped on Sunday.
I know it's not in this version of the highway bill. I know there are efforts to get it included in that, or as it has been introduced as a standalone bill for the past few Congresses.
Got it. All right. Well, maybe let's round it out here. Let's talk about like just some quick practical takeaways. Our good friend Bert and common cohort here would just totally skewer us if we didn't offer some practical takeaways at the end of this episode. So maybe starting with Nathaniel, kind of top 3 broker, takeaways, like immediate action, if any. People are calling you.
Yeah.
Their hair is on fire. What are they?
Yeah, I would say, and I'm going to steal one from Dan, with apologies, Dan. But I mean, look at your policy and look at your underwriting documents and make sure that you're doing the things that you said you were going to do. Again, that's not so much a outward facing liability issue. Is just let's not jeopardize that coverage that you're paying for. And then I would say that number 2 for a broker would be making sure that you understand what your vetting criteria are and that it's an informed decision and well documented, and one that you feel like gives you a reasonable, a good argument that you've exercised reasonable care. I would say those are really the 2. I'll stop at 2. I'd say those are the 2 main takeaways I'd be giving to brokers this week.
What about carriers? Any thoughts there from Dan? Maybe any thoughts on the carrier side? If the people you think your thoughts there?
Carriers that have brokerage operations, or are we talking about small carriers?
Well, yes.
I think carriers that have brokerage operations need to have renewed vigor and vigilance here. I think they need to talk to their broker right away and ask the hard questions. What is my insurer of my broker contingent liability? What's their position on all of this? How stable are they? How concerned are they? What can I do as a broker affiliated to my motor carrier to be more attractive that maybe I haven't been doing before? How can I have more underwriting options available to me the next renewal? Hoping I don't need them, but why not go ahead and prepare myself to be more attractive when others aren't? I think getting real proactive on understanding that relationship is critically important. And if you're a small carrier, tell your story. I mean, if you haven't populated, CSA scores yet, if you don't have good data, why wouldn't you market yourself to your major sources of capacity? Stress the things that are strong about you. I mean, there is information, right? That driver of that truck has a history. That equipment has a story. And I think you have to get out in front of that so you just don't get left beside for lack of data.
That's a great point.
I'm going to add one to Nathaniel's. He only gave us 2, and I'll add one to Dan's too. If you're a broker, call Nathaniel. He's going to help you. And if you're a carrier, call Dan. For Pete's sake, he's going to help you. If you just want to hear a good joke, call Prasad, because he's got a lot of them.
Yeah, and on that point, Prasad, you get the last word here. Any final thoughts from the word up on high?
I'm going to sound like a broken record here, but I do think all of this brings to light the need to address tort reform. I think as a supply chain, the overwhelming percentage of carriers and even brokers that participate in this supply chain are interested in safety, are interested in performing well. And the pressures that these excessive verdicts are creating are detracting from the ability to make investments in safety technologies, to pursue more safety practices that benefit all of us. So I think there has been focus, there has been some movement on tort reform, but I think this is another impetus to putting some more engaged effort on that front.
I think that is a fantastic final point. I think all too often we see our industry, it's fragmented on issues, right? One portion of the industry supports something, the other one doesn't. But to me, I think this is something that that we all would agree with you that we need reform and we should unite behind it for sure.
Agree. Awesome. Well, this has been one of my favorite conversations so far on this podcast. So I thank everybody for your time, and look forward to seeing you again, Prasad, pretty soon, a conversation on predatory towing. So that'll be fun as well.
Looking forward to it.
Yeah, for sure.
Neither of
So
those things is
everybody,
true.
appreciate your time.
Nobody looks forward to predatory towing. But thanks for doing it. It needs done.
Yeah.
That's right. Appreciate you all.
Thank you very
Thank
much.
you,
Appreciate
everyone.
it. All right. Thanks for listening to this episode of True North Truck Thought. If you enjoyed the topic today and want to tune in for future conversations here on the Triple T Pod, make sure to follow us. Also, please don't hesitate to let us know which topics you want us to cover in future episodes. Drop us a line in the comments section or send us an email to transportationnews@truenorthcompanies.com. Thanks and have a safe day.